I had intended, or I had hoped, and I had asked the court to have a do-over on the anti-SLAPP hearing.
Good morning, everyone.
Yeah.
We have Mr. Phillips.
Good morning, Your Honor.
Good morning, sir. And who is representing Jennifer Abrams and Abrams Law Firm?
Good morning, Your Honor. Joseph Garin for Abrams.
Okay. And then Mark DiCiero and Dave Schoen.
That's David Clayson.
They have that, and from Louis Brisbois, correct?
Yes, yes.
All right. I've been appointed by the Supreme Court as a senior judge in this particular matter. We did note that April 14th, 2023, Senior Judge Cherry ruled on a motion, an anti-SLAPP motion, and he had directed the prevailing parties to prepare the formal order for his ruling. And apparently, as of today, no order has been prepared. Is that correct, counsel?
Your Honor, what happened was Justice Cherry granted the motion, directed us to prepare an order. We ordered, I believe, the transcript so that we could prepare it. We went back and forth with Mr. Phillips, and we were planning to submit our version of a proposed order, and he filed a motion to disqualify Justice Cherry. And based on that, no order could be entered. So that's kind of the cases, right?
I reviewed Odyssey, and I did not see that a transcript had been prepared for the April 14th hearing. Is that correct?
I thought that it had, but I can review the file and let you know, Your Honor.
Well, I took the liberty of contacting the court recorder's or reporter's office. What's the right phrase? Reporter's office. Okay, recorder's office. And I ordered that they prepare a transcript for the April 14th, 2023 hearing. My understanding is that they expect 3 weeks to have that transcript prepared. What I will do is set a 3-week status check to make sure the transcript's prepared, and then counsel will need to have the order, the formal order prepared. All parties, I want them to look over the proposed order as to form and content. And I always tell attorneys that approving form and content doesn't mean you agree with the decision, but you agree with the order is consistent with the judge's ruling. Okay, so we'll go out 3 weeks or so for today. And what I'm going to do is, because it's through the senior program, I will have the senior staff set out a notice of hearing, which will be 3 to 4 weeks from today. Okay, anything to add by any of the parties?
Your Honor, may I be heard?
I'm sorry.
This is Phillips, the plaintiff.
Yes,
I wish to add that there is indeed a transcript, and I know this because I've read it. So there is already a transcript, and I'm happy to make that available to the court right away to save time and money.
That's fine. No, if there one, I just didn't see it in. It was, for some reason, it did not appear to be filed in Odyssey. If there is in fact a transcript, if you could provide a copy to the other party. I don't know if was it filed? Does anyone see it filed in Odyssey?
I believe I filed it, Your Honor.
Okay, Ms. Clerk, can you look that up, please? It would be subsequent to April 14th, 2023. The clerk's checking right now to make sure.
And Your Honor, may I bring up another point while we're waiting?
Yes, you may, but one moment. The clerk's checking the record.
Thank you, Your Honor.
Judge, I just found it in my directory. It's 62 pages.
I'm sorry?
It's 62 pages long.
What's the date of filing?
Date of filing is July 11th, 2023.
All right, counsel, then we have that. Please submit the order to the court. Have it to the court within 14 days from today. If you can, again, provide a proposed order to the other parties, see if they'll sign off approved as a form and content. If anyone believes that the order prepared by counsel is inconsistent with Judge Cherry's ruling, then please just submit your own order to the court, and then I will review the orders as well as the transcript and sign the order that is consistent with the ruling.
Judge, just to be clear, if we cannot agree within 14 days on the language, do you want the parties to submit competing orders?
Your proposed order, yes.
Okay.
You were directed initially, and then, so everyone's got the transcript. And so if there's any disagreement as to the content of the order, I will review the transcript. I have reviewed the entire history of this case. And then I will sign the order that is consistent with Judge Cherry's ruling.
Okay.
And then at that subsequent to that, to the order being filed with the court, any aggrieved party can file the appropriate motions for reconsideration if that's in order. I don't know, or any writs to the Supreme Court. Again, that's strictly up to the parties. Okay. Any other question, counsel?
I don't have any.
Yes,
No, Your Honor.
I had a question. Yes, sir.
There's just 2 points I wanted to make, and I will be brief. I made a motion to disqualify Judge Cherry, and Chief Judge Weiss indeed disqualified that judge. And the judge was biased at the time he made the ruling because he was acquainted with Jennifer Abrams and Mark DiCiero and David Schoen, and the judge failed to disclose that. So it's my position, without getting too far into the weeds, it's our position that, or my position, that the ruling is a product of bias and could never stand. And secondarily, the second point I wish to make is Judge Cherry ruled against me because I didn't prove the statement false.
Let's don't get into the specific facts of the case. My understanding is that your motion to disqualify Judge Cherry was subsequent to April 14th, 2023. Is that correct, sir?
Well, but it was based on what happened that before that.
Sir,
Well, yes, it came after. Yes, it did come after naturally,
Right.
but it was based on the earlier facts.
okay, so we're going to have counsel prepare the order. And if you feel that a motion for reconsideration is appropriate, then please file that motion after whichever order is signed by the court.
It's just sort of what I wanted to say, and I'll do one sentence here, is that on anti-SLAPP, the burden is on the moving party.
Hey, sir, you're arguing the merits of the case.
That's the
Okay,
law.
right now. Today, we are dealing with getting an order filed with the court so then the parties can move forward with whatever action anyone wants to take. But we have to have a formal court order. And that's all we're doing today. And then, like I said, so everyone understands, counsel is going to submit his proposed order. If you agree with the form and content, please sign it. If you feel it is inaccurate, then please submit to the court your proposed order. All right. Any other questions? Mr. Clayson, do you have any questions?
No, Your Honor. Thank you.
Anything else, Mr. Phillips?
Look, I promise this will be the last one. I had intended, or I had hoped, and I had asked the court to have a do-over on the anti-SLAPP hearing, not just to re-sign the order.
If you feel that that is appropriate, please file a motion so then the other parties can address it and the court can review your points and authorities. And I would say that to any of the attorneys here today. Okay? All
Thank
right.
you.
And I will set this matter on a chamber's calendar 3 weeks from today to make sure that the court has received either one order or competing orders, and then we can go on from there. Okay, so I think we can just go ahead and do that now. Just it's going to be a chamber's a calendar 3 weeks from today.
That is September 4th in chambers.
All right, counsel, I look forward to the order or orders. Thank you.
Thank you.
Thank you.
Thank you, Your Honor.
You're welcome.